to notice. Legal notice should be replied within the stipulated time. If not replied within the stipulated time, it can prove to be beneficial to the addressee. After receiving the notice, the following points must be kept in mind. First, there should be a careful reading of the legal notice. Second, contacting the lawyer who has sent you the legal notice, and if the contents of the legal notice are not clear, then contacting a lawyer to explain you the contents of that legal notice as well. Briefing the lawyer, entire matter should be briefed to the appointed lawyer. Then sending the reply. The reply notice is sent either through a registered notice or courier. Once the lawyer drafts the reply notice on your behalf, the lawyer keeps the copy of reply notice for future reference. Now, what one should do when they receive a legal notice? The first thing to do after receiving a legal notice is to call the sender of the notice with the aim to resolve the dispute amicably. Though it is not mandatory to reply to a legal notice, but still it is advisable to send an appropriate reply to the legal notice. Third, if in any case if one fails to send a reply to a legal notice, the other party may use that as an advantage, and while drafting the petition, they may blame for not adhering to the requirements of the notice, for which reason the case has been filed. Then, if in one's opinion the facts that have been stated in a legal notice are not true and he needs to contest a legal notice, then he can take consultation from an experienced lawyer, seek his assistance, and draft a proper reply to legal notice, denying the content stated in legal notice. The legal notice must be sent via registered post or courier. While sending a reply to the legal notice, check whether the claim is in legal notice is time barred or not. If the claim is time barred, then one should only reply that the claim is not within the limitation period. There are some common mistakes while replying to a legal notice. First, time. The most common mistake is not replying the legal notice on time. The sender should try to reply the notice as soon as possible and within the stipulated time as mentioned in the sender's notice. Otherwise, the sender can take strict actions. Second, reply. The mistake the party makes is that they do not reply in a proper and prescribed manner. The notice should be properly replied. If the party is unable to understand the terms of the notice, a professional advocate should be consulted. Third, sections. The mistake that is made is that the party forgets to mention the sections under which it is sending the notice. It is important that the party should be aware of the relevant sections under which it is sending the notice. Then, date. The people forget to mention date in the notice. It is very important to mention date in the notice. Sign. If the party consults an advocate, then it should not forget that both the parties and an advocate's signature is required. Address. The present address of the sender should be mentioned so that it reaches to the proper person in proper time, causing no delay, and delay might act against the party later. That's why. Contact. The sender's present working phone number should be addressed. That's all. Thank you.